All right. Okay, everybody. Welcome to week 4, Family Violence and Communication Pointers. Tonight, our guest speaker is Valeska, and I am Jennifer B. I'm going to be the moderator tonight. So just, again, just some reminders, some upkeep. So we are on the ancestral, unceded, and territorial or traditional territory of the Musqueam, Squamish, and Tsleil-Waututh Nations. So just a reminder again about AC Friends of Courts. It's a nonprofit organization. It began in 2011 with its first legal forms workshop being held at the Access Justice Center at the Provincial Courthouse. Our legal forms workshops helps British Columbians access affordable legal help for a variety of areas of law. Presently, we have approximately 45% of our clients are dealing with a family law matter. And this school in particular is the first of its kind in BC. So again, we want to acknowledge the people who have helped us form this school, Kylie Wong, Dom Batista, Dana Cornwell, and Andrew Pillier. And again, just a reminder to everybody that AC Family Law School does not give legal advice. This is legal information only. So again, just a reminder, the difference between legal advice and legal information. Legal advice is when you're asking questions directly linked to your case. Legal information, again, that's not directly linked to your case. So if you're asking about, again, the difference between provincial and Supreme Court, that's legal information. And again, so some housekeeping. All sessions will be recorded and emailed to everybody who's attended tonight. We remind everyone that the recordings and reference materials are not to be redistributed to anybody else outside of this school and who have been here tonight. And we do thank you for your cooperation on this. For anybody who hasn't yet, please do send your participation agreements. And again, mute your microphones and turn off your video. Put all your questions in the chat box. And please try your best to keep details of your case private, and do respect people, others while they're communicating. And if you have any questions or concerns after tonight's session, you can send your questions to info@litigantschoolbc.com. So please respect speakers, AC volunteers, staff, and other registrants. A reminder that any kind of abusive or harassing language or behavior will not be tolerated. We reserve the right to remove any individuals who engage in behavior that the course facilitators determine to be disruptive, abusive, or harassing. So we're in week 4, objectives and outline. So it's about family violence and best interests of the child as per the Family Law Act. Conduct orders as a way to manage harassing or intimidating behavior from your former spouse. Communication pointers, what to do when violence is involved, how to keep yourself safe while moving your case forward, how to talk to your former spouse, best practices and tips on etiquette towards each other to minimize arguments when speaking with one another. What to expect and how to talk to opposing counsel, how to talk to your children, and considerations for pressure to engage in alternative dispute resolution. So about our speaker tonight, her name is Valeska. She is a lawyer at Silver Cylinder LLP and also works with Rise Women's Legal Center. So now I'm going to hand it off to Valeska.
Hello, everyone. Apologies for the background. I thought I would be in my office or at home today, but I'm unexpectedly running this from my in-laws. So I'm probably going to stop my camera after a while unless we're actually talking at the Q&A. Okay, so I'm just going to find where I can present this. Okay. So we'll start off with family violence. I've tried to section it off, and after each section, there will be a portion for Q&A. So hopefully we can get to questions at that time, though if you have any questions, feel free to drop it in the chat at any time. And Jennifer will help filter through some of those questions that have legal advice portions. So the definition of family violence can be found in the BC Family Law Act. I don't know if you've covered that in any of the previous topics, but the Family Law Act is accessible to everyone. If you just type in Google, BC Family Law Act, it's the first one that comes up. And so this is actually in the definition section, or section 1. And it says family violence includes with or without an intent to harm a family member, physical abuse, sexual abuse, attempts to physically or sexually abuse another family member, psychological or emotional abuse, and in the case of a child, direct or indirect exposure to family violence. So we'll get into this more as we go on in this presentation. But the important thing to note from all of this is family violence is more than just physical abuse. It doesn't have to be physical or any kind of aggression or anything like that. If there's been a pattern of control or coercion or manipulation, or even if it's just verbal abuse, if there's a pattern of this being an ongoing thing, more likely than not, it probably counts towards or supports a finding of family violence. In the case of children, especially, you don't need to abuse the child for there to be a finding of family violence against the child. If you have, spouse number 1 and spouse number 2, and they're abusive towards each other, or, let's say one spouse is abusive towards the other spouse and the child is direct or indirectly exposed to this, then there will be a finding of family violence towards the child. So there are the common examples of family violence. And when we think about family violence, obviously we think about, the domestic abuse cases where one person assaults another person, or someone's, throwing plates and dishes over at the other person, or there's like physical altercation or yelling and name calling, things like that. But there's also more subtle or less common examples. So abusive correspondence, so exchanging, emails where you're perhaps calling the other person names, or you're being rude, or if you're sending, 200 emails or 200 text messages a day, or you're making threats, things like that. So that would count towards the finding of family violence. Litigation abuse, it's a very high bar, but even if there's conduct that doesn't quite meet the threshold of litigation abuse, the conduct itself can factor in towards the finding of family violence. So for example, if you're filing multiple court applications all the time, if you're filing numerous very lengthy affidavits that then puts pressure on the other person to then respond to all of these things, and it's very draining on their resources, their time, their energy. So that can ground a finding of litigation abuse or family violence. Withholding of child support. So a failure to pay child support in and of itself will probably not ground a finding of family violence, but there have been cases, and we'll talk about this later on, where if the withholding of child support was intentional and directly intended to impact the other person financially or impact the child financially, then in that case, it could be found to be a form of family violence, because financial control is a form of family violence. And as I've mentioned before, in the case of children, direct or indirect exposure. So even if, the children were never around when you're physically, when their physical abuse against the spouse is happening, if, the children come home and the house is in disarray and there's furniture all over the place, or, one parent is crying in the bedroom and they have bruises all over the place, or they're in the hospital, those kinds of indirect exposures still count towards family violence. So this is a case that's very often cited for family violence. It's one of the leading cases on family violence today. It's the case of Berenject and Grebliunas. It's a 2022 Supreme Court of Canada case, very recent. The case itself is actually on relocation, but it has quite an in-depth analysis over family violence. And Justice Karakatsanis here says that the suggestion that domestic abuse or family violence has no impact on the children and has nothing to do with the perpetrator's parenting ability is untenable. So historically, and I say historically, but not that long ago, let's say like 2000s or before, there's this idea that, a parent who's abusive to the other parent can still be a good parent to their children. And now we're starting to realize more and more that, if you're the kind of person that can beat up your spouse or call them names or, try to coerce or control them for them in order to make them behave in ways that you want them to behave, you're probably not a very good person. And that probably translates to other areas of your life. And you're probably not going to make a very good parent. And so courts these days are starting to recognize that more and more. And it's this idea that abuse, even when it's not directed at the child, is still relevant to the perpetrator's parenting ability. That being said, especially when it comes to children, but just even generally speaking, family violence is predicated on actual harm. In cases where there is no harm, it's going to be a bit of a stretch to say that family violence has occurred. And we come to the case of CLM and MJS, 2017 BC Supreme Court case, where the court held that the courts must be careful not to just label anything as family violence if there's no evidence that the child has suffered any physical or emotional harm. They went on to say that the provisions in the Family Law Act relating to family violence are intended to address a serious social issue and to protect children and spouses from actual harm or danger. And this is in part in recognizing that when parties separate, there is often, unfortunately, some degree of animosity, especially where court proceedings are concerned. There's going to be a lot of tension and some unpleasantness going around. And normal, reasonable, good people, they have their weak moments, right? And if you have that one outburst or something like that, but it's very isolated and the children weren't exposed to it and they're fine, that in itself may or may not ground a finding of family violence. But if there's certainly if there's a pattern, if it's ongoing, and if it results in harm to the children, whether it's because the children are picking up on the stress or what have you, all of those things make it more likely that the court will make a finding of family violence. Okay, I'm going to pause here before we get more into the rest of the presentation, but any questions so far on family violence or the definition of family violence and what counts, things like that? That's great. Okay, if we're doing okay, I'm going to move on. So related to the concept of family violence is the concept of best interest of the child. There's a lot that can be said about the best interest of the child. It's a very central focus and concept in family law. So this particular portion that we're going to cover is just as it relates to family violence, not best interest of the child generally. The best interest of the child and how it considers family violence. There's a bit of a difference between the Divorce Act and the Family Law Act. I don't know if you would have covered or will cover the difference between the two statutes separately, but for the purposes of today, suffice it to say that if you're married, you have a choice between the Divorce Act or the Family Law Act. If you're not married, then it will be the Family Law Act. If you're in Supreme Court, you have a choice between the Divorce Act and the Family Law Act. If you're in provincial court, it will be the Family Law Act because the provincial court does not have jurisdiction over the Divorce Act. And they both are very, very similar. Substantively speaking, there's going to be very little to no difference. But that being said, the provisions themselves do write different, and the language they use is a bit different. So in the Divorce Act, you would be looking at section 16 sub 2. And it says that if you're considering the factors referred to in subsection 3, which is the factors concerning the best interest of the child, the court shall give primary consideration to the child's physical, emotional, and psychological safety, security, and well-being. The sort of mirror or comparable provision in the FLA would be section 37 sub 3, where it says that an agreement or order is not in the best interest of a child unless it protects, to the greatest extent possible, the child's physical, psychological, and emotional safety, security, and well-being. So in this sense, the FLA uses slightly stronger language because it requires not only that it be a primary consideration, it requires that you must maximize the child's physical, psychological, emotional safety, security, and well-being. If you're not protecting it to the greatest extent possible, then whatever order it is that you're planning on making is not in the best interest of the child, and it's not permissible under Section 37. Whereas in the Divorce Act, arguably, even if it's not maximizing this to the greatest extent possible, as long as you're giving it primary consideration and it's at the forefront of your analysis, you're probably fine. So slight difference in language there. Practically speaking, in terms of the actual analysis, it very rarely has any real impact. But it is interesting to note that the language is a little bit different between the two. The factors themselves are also quite similar with a few differences. So in the Divorce Act, they say, in considering the impact of any family violence under paragraph sub 3J, the court shall take the following into account, and then it gives a list of factors dealing with family violence. In Family Law Act, it's under Section 38. And it says, for the purposes of Section 37, which is the best interest of the child provision, sub 2G and H, which deals with best interest of the child in relation to family violence, a court must consider all of the following, and then it goes off to give a list as well. So we'll take a look at the list in the next few slides. So this is a set of lists that is found in both the Divorce Act and the Family Law Act. So both the Divorce Act and the Family Law Act requires you to consider the nature, seriousness, frequency of family violence, if there's been a pattern of coercive or controlling behavior, whether family violence was directed toward the child or not. So if it's directed toward the child, then it does make it worse in terms of assessing the best interest of the child. But in cases even where it wasn't directed at the child, that doesn't mean that it's not relevant. Any physical, emotional, or psychological harm to the child. Again, in most cases, some amount of harm, you need to be able to prove that there's been some amount of harm. Otherwise, arguably, no harm, no foul. If the child is fine, then likely whatever's been going on, especially if it's very situational and limited to the relationship, and it's unlikely to occur in the future because the parties have separated and things have stabilized, then, possibly it's not going to be that relevant to the best interest of the child. Although there is a strong line of case law that states that even where family violence is historic, that doesn't make it irrelevant. So courts still are required to consider historic family violence. Steps to prevent further family violence. So whether the perpetrator or the person who was responsible for the family violence has taken any steps to make sure that it doesn't happen again. And any other relevant factor or matter. So this is a very broad category intended to give the court a lot of room and flexibility to consider anything else. The primary reason being because family law is very fact and case specific. There is no one size solution to anything. Every case will turn on its facts. Everything is very different. So because of that, the statutes want to build a lot of flexibility to give courts the discretion that they need. So this is the rest of the list, and this is where we start to see things have a little bit of a difference. So the Family Law Act requires the court to consider the recency of family violence. So presumably this means, if it's very long ago, then it's perhaps less relevant or should be given less weight. If it's very recent, then arguably it should be given a lot of weight. Whether any family violence has compromised the safety of the child or other family members. So this is only in the Divorce Act. Fear for safety of the child or other family members. This is only in the Divorce Act as well. And whether the child was exposed to family violence not directed toward the child. So this is only in the Family Law Act. I want to note here that even though these factors are only specifically enumerated in either the FLA or the Divorce Act, that doesn't mean that courts won't consider these things. It's just they're under the FLA, they're required to consider recency and whether the violence was directed to the child or not. But even under the Divorce Act analysis, under that broad umbrella heading of any other factor, if you are the parent that's pleading that family violence has occurred, if there's any argument to be made here that would help your case, then you should certainly bring it to the court's attention. And the same goes if you're arguing this under the Divorce Act or the Family Law Act. Okay, any questions so far about defining family violence, what counts towards family violence? If there's any difference between the Divorce Act, Family Law Act, things like that.
So regarding family violence, what can one do if they don't have proof of it? So I guess maybe more on like verbal, if there's no actual written communication, what could one do?
This is a tricky question. It's a very good question. Thankfully, including in the Supreme Court case that we saw just now, the Berendt and Grebliunas case, in there, the court specifically does acknowledge that family violence often happens behind closed doors, and very often there isn't any proof. That does happen a lot. Unfortunately, when that is the case, then your proof or your evidence would be your testimony. So in the case of if you're going through this in like a chambers application or a family management conference or, a hearing in provincial court or a summary trial, then the evidence would go by way of affidavit, which is a sworn statement, and it would be your story. So you would write down what happened in as much detail as you can manage, and then you would have it commissioned by a commissioner of oaths. If you're in provincial court, you can get that done at the registry for free. If you're doing it in Supreme Court, you can get that done at the registry for $40. Any lawyer or other commissioners of oaths can do it as well. Some law advocates and support workers would have taken the certification, and they can do that. And so you would basically state your case, and then the other person would most likely disagree and say, that's a bunch of lies, that's not what happened. And then it would basically be, a he said, she said, or a she said, depending on if you're a same-sex couple. In the case of a trial, it would be essentially the same thing, except it would go by viva voce evidence. So one person would be on the stand, and they would be there in person telling the court the story. And then the other person would also have this the same opportunity where they would also be on the stand and tell the court their story. And then the court would have the difficult job of trying to determine, which version of story is true. So, if you have like text messages or screenshots or recordings or things like that, that can be very helpful because it can certainly corroborate your version of the facts. But in cases where that doesn't exist, and there are lots and lots of cases where that doesn't exist, then that's okay. It doesn't mean that you're prevented from bringing that story to the court. It's just that, just be mindful that the court may or may not choose to believe your side over the other person's. Hopefully that answers the question. If that doesn't, please feel free to follow up. I will say I can't actually see anything in the chat, so I will rely on Jennifer to pass all of the questions.
Is emotional abuse, is that treated like physical abuse? Or is that
Yes and no. It's treated like physical abuse to the extent that even if there is zero physical abuse, a finding of emotional abuse can ground a finding of family violence that can then result in very real consequences. So, for example, like severely restricting one person's parenting time or saying that you're not allowed to communicate with this person directly. You can only communicate to them through counsel or through the support worker or through this one email address and no more than once a day or something like that. It's not treated the same as physical violence to the extent that courts still do have a bias. It's unfortunate. We all do. Everyone in the legal profession suffers through this, that there is still this bias that physical abuse is somehow more serious, and it's taken more seriously than all other forms of abuse. But that doesn't mean that that's correct. The bias does exist. We're working on it. We're trying our best. With training and time, it is getting better. The one thing where you'll see the most difference is if you're applying for a protection order. It is not easy to get a protection order without any form of physical violence. But that's just based on this idea that a protection order is meant to protect your physical safety. Typically, if you're just worried about, like your emotional well-being and your mental health and things like that, which are all very valid and certainly something worth protecting. The idea, though, is that you should be able to manage that yourself by having good boundaries and just, you know, changing your phone numbers or blocking the person and not replying, etc., etc.
Okay, so there's two questions or three questions here that I'm not sure if they can be answered, but do you want me to read them out loud?
Sure, we can try.
A situation where a partner continue to expose the child to multiple partners, where do you categorize such a case? So I'm guessing if one partner has multiple significant others or consistently introduce him into a new person, would that be categorized as family violence? And then it's a two-part question. And also advise the child not to inform the other partner. What is the best way to handle such a situation?
Okay, that last part about what is the best way to handle, definitely can't answer that because that is definitely legal advice.
Yeah.
But in terms of like a hypothetical example of, you know, this one person introducing the child to multiple partners, this is one of those things where, you know, courts give a lot of lax and slack to parents. And courts don't typically want to intervene, and they may, you know, objectively recognize that one particular parent's parenting style is not the best, you know, and we can think of lots of examples of this, right? Like one parent, you know, lets their child play really violent video games or stay up until 2 a.m. in the morning or not do their homework or whatever it is, or eat a bunch of candy and not have nutritious meals for dinner or something, something, something. So those are all things that, you know, a parent might very well disagree with for very good reasons. But whether or not that amounts to family violence, unless it's to the extent that it counts towards like gross neglect of the child, probably not. At that point, then, you know, that parent might start looking into exercise of parental responsibilities, and they can say, parental responsibilities falls under the umbrella of parenting arrangements. And then they can say, you know, this parent does not demonstrate good judgment. And here are some examples that I can show where they don't demonstrate good judgment. And because of that, in cases where a parental responsibility needs to be exercised or significant decisions need to be made about the child, and, you know, this parent and we don't agree, I would like to be able to have the final say because clearly, you know, they don't exercise good judgment, and we shouldn't trust them to have the final decision-making say in the event that we can't agree. So that's one way to deal with it. As far as family violence goes, you know, if with respect to the other multiple partner situation, it depends, you know, are these other partners dangerous? Are they exposing the children to drugs or substances, things like that? That's not great. If that's the case, then probably you're getting closer to the realm of family violence. If it's just a matter of you know, the emotional difficulty that comes with that, if it's causing very real harm to the child, if they're, you know, exhibiting symptoms of distress, if they're withdrawing, if they're changing their behavior significantly, acting out in school, things like that, where you can point that, you know, this particular event or incident or behavior or decision of this partner or your former spouse has resulted in very real harm to the child, then yes, you can argue that this is a form of emotional abuse and emotional violence, and that is family violence. But again, it really depends on the specific set of facts.
Thank you so much. So this other question here, are there consequences to not being believed about family violence? And they say, for example, in the Myers study, apparently women were punished much more than men when they were not believed.
Yes,
No.
there are very real consequences to making a claim of family violence and the court not believing you. And yes, it is worse for women than it is for men. It's very unfortunate. There's still a lot of gender biases, and I do genuinely think it works against both genders in the sense that to some extent, men are less likely to be believed when they claim family violence. But that being said, when women are not believed, the consequences are much, much worse. One common one is that they can be seen as alienating the child. Alienation is a loaded term. We're not going to have time to talk about it in the span of 2 hours. But suffice it to say that it's this idea that I am turning my child against the other spouse. And so alienation is a very common sort of almost like countermeasure or counter tactic where, like, let's say, you know, in the stereotypical most common example, because of the gender biases that plague family violence, you know, mom says dad is engaged in family violence and is perpetrating family violence. And then dad counters by saying mom is engaging in a campaign of alienation to try and damage the relationship between the children and myself. That's very common. And so in the event that the court doesn't believe mom, that the family violence was real, then the court may view that as one factor supporting dad's argument that mom is making all of these false allegations and all of these false claims to try and gain a quote unquote like advantage in family court over the parenting arrangement proceedings or what have you. So yes, there are consequences. Hopefully you can make good decisions as to whether or not the family violence is something you want to bring up. I do recognize and sympathize that this is one of those, you know, caught between a rock and a hard place, right? You're screwed if you do and you're screwed if you don't, because if you bring up family violence and you're not believed, then you are engaging in a campaign of alienation and you are trying to besmirch the name or the reputation of this other parent who's just trying their best. How could you? And you're a terrible person. But then if you don't bring up the family violence and there is family violence, then you're a terrible parent for not protecting your child from the family violence and not bringing it to the court's attention. So it's a very difficult situation. There is no right answer for that. And in every case, you're gonna have to hedge your bets on what's the right call.
No, that's a really good answer. This other one, is cheating classified as abuse?
That's an interesting one. I
Yeah.
think when it comes to you as a person, if you're saying that, you know, my spouse cheated on me and that's family violence against me, I think in and of itself, it's very unlikely that a court is going to agree with you. If there's other factors surrounding that, right? Like there's a lot of lying, the person, you know, is hiding assets and is trying to intentionally you know, reduce whatever settlement you can get in family court at the end of this, or if they're intentionally, you know, gaslighting you and it's getting to the point where you have depression or PTSD or other things, and you start to think that maybe I'm going crazy. And there's very real life impacts on you and there's significant emotional harm, and then maybe, right? If it's to the child, then it depends, right? Like, is this something where they're involving the child, or maybe it's impacted the child really significantly, or if, you know, person who's cheating on the other person has also just abandoned the family entirely, including the child, or if they're prioritizing this new person financially, emotionally, what have you, instead of their children, maybe. So I think the answer to that is it's going to really depend on what harm has resulted as a result of the cheating.
Yeah, that one's a tough one. It's a really tough one because it's like very gray.
Yeah,
depending on the
that's difficult.
situation. Yeah. And then there was some other questions that I can quickly answer, but most of it was about getting links to the cases that you quoted. And I can get links for those that can be sent when you get the recording. So
Are they going to get the presentation? The
yes,
slides? Okay, let me go back really quick. I'm pretty sure I put the links. I'm usually pretty okay at doing that.
yeah, I saw it was on Canly.
Yes, so
Yeah.
Canly is free and available to everyone. So if you just copy paste this link on your browser, you should be able to locate the case.
And you'll get the slide, and we'll just make sure the links they're hyperlinked so that it's easier to access those cases.
Okay, so the next portion, we're going to be talking about conduct orders. So conduct orders, you might hear it called that a lot. They're actually orders under the Family Law Act under Division 5. And in Section 222, and there's a section and the heading says purposes for which orders respecting conduct may be made. So at any time during a proceeding, the court has the jurisdiction to make an order, any order, for any of the following 4 purposes: either to facilitate settlement or resolution of an issue, or B, to manage behaviors that might frustrate the resolution of a family law issue. So B is a very common one that a lot of things will fall under. C, to prevent misuse of the court process. So for example, misuse of the court process is, I can't say to you like, okay, well, either transfer me this money now, or, give me the children for all of Christmas, or I'm going to go apply to court for this and that. So that's not okay. Courts are not, if you're going to court to apply for the thing that you're asking for, sure. But don't say you're going to apply to court for some ancillary purpose. It's not meant to be there as that kind of threat. And D, to facilitate arrangements pending final determination of a family law dispute. So this is just, they're interim orders essentially, but they're not really meant to be substantive. It's meant to manage more the conduct of the parties. So this is an example of a conduct order. It could restrict communications. And I underlined here the very beginning of this section because it says, unless it would be more appropriate to make an order under Part 9, a court may make an order setting restrictions or conditions respecting communications between parties, including respecting when or how communications may be made. And it's very important to remember that this is not meant to be a lesser form of a protection order. A protection order is meant to be a standalone order. It doesn't necessarily have to have anything to do with the rest of the family law stuff going on. Protection order is intended to protect the safety of a family member, whether it's the parents or the children, from any threats of violence from one spouse. Conduct orders are meant to manage the behaviors of the spouses for the life of the family law file. And for example, this is to say, like, if one spouse is sending 200 emails or text messages a day, or calling, the other person a bunch of names, or making Facebook posts that are very damaging, or they're spreading lies in the community, or whatever it is, that's not going to help settlement. And that's certainly not going to help the litigation. It's just going to increase animosity between the parties, and it's going to make reaching a resolution or settlement much, much more difficult. So in that sense, we can have orders restricting communications or conduct in order to facilitate, hopefully, as amicable a settlement or resolution as possible. They're different things. They're not meant to be used like interchangeably, and it's even though practically speaking, a lot of people do see it this way, where they're like, okay, well, I don't have enough for a protection order, but I can get a conduct order instead. They do serve different purposes. So in this case, if your concern is safety, then you should be looking for a protection order, not a conduct order. So this is an example of, well, two examples actually, of conduct orders. So this is taken from the court order pick list. You can access this. The court order pick list is also free and available to everyone from the courthouse libraries. There is a Supreme Court pick list and a provincial court family pick list. They're very, very similar, and honestly, it doesn't really matter that much. A court's not going to get mad at you because you used the wrong one. And if you have difficulty trying to find it on your own, go to the courthouse, any courthouse library. The courthouse library staff are very, very friendly. They're very helpful, very knowledgeable. And if you just tell them that, hey, I'm looking for the family law pick list, they should be able to direct you, and it's downloadable. There's a PDF and a Word version. So for the single communication restriction, so under section 225 of the FLA, which is the section we just saw, one person, so let's say, Mary, will have no communication with the other person, let's say Susan, except, and then you can describe specific exceptions. So for example, except as necessary to facilitate pickup and drop off of the child, and only through text message unless it's an emergency, or except to facilitate the resolution of this family law matter, or except, indirectly through counsel, or a third party dispute resolution professional that's been given a copy of this order, et cetera, et cetera. Or you can say, if it's a mutual one, then you can say, under the same section, then the parties will communicate with each other only. And then you can say, through email, or through text message, or through phone. And you can make it staggered as well. So you can say, look, if it's something substantive and significant, then email only. If it's only about day-to-day things like, hey, I'm going to be running 5 minutes late, I'll meet you at the Tim Hortons, or hey, I can't make it to the SkyTrain, can we meet, at this random park instead? Or I'm running 5 minutes late, 10 minutes late, etc. Stuff like that. Then text message is fine. And then you can say, in cases of emergencies, then phone calls. You could also technically make orders respecting residence. This is more commonly done through a protection order. In a protection order, you can include as a term in the protection order that one person will remove their belongings from the family residence, or one person will remove their belongings from some other residence, or what have you, supervised by a peace officer, et cetera. So that's very common in protection orders. You could also technically do it as not a protection order. And you can say that, a specified person doesn't have to be the police. It can be your friend or your mom or whoever, a neighbor, etc., a trusted person, a support worker, an advocate, to supervise the removal of personal belongings by another person from a residence. This is just the very general term, and it says that a court may make an order requiring a party to do one or more of the following. C is do or not do anything, so very broad, as the court considers appropriate in relation to a purpose referred to in section 222. So that was the stuff that we talked about, where it was to facilitate resolution, or to prevent behaviors that might frustrate resolution, or to facilitate arrangements pending a resolution, et cetera. So again, it is intended to be very broad. The orders can get quite creative depending on the circumstances of your case. So yeah, quick reminder. So these are the terms that we talked about. So these are the purposes for which those orders may be made. So this is a sample term for conduct orders that are very frequently included when there are children. They're often called standard, like best interests of the child conduct orders, or something along those lines. They are found in the PIC list. So it just provides that, parties will put best interests of the child before their own interests, encourage the children to have a good relationship with the other parent, make a real effort to maintain polite, respectful communications with each other, et cetera. Very, very generic, very boilerplate terms. They're good to have. It doesn't hurt. I will say, though, realistically, practically speaking, to be perfectly honest with you, whether or not they're enforceable is, kind of, let's just say it's up there. They're not super enforceable, because I mean, realistically, like, well, what's the court gonna do? But at least if you have this order and then the other person breaches that order or continues their behavior that is now against this specific order, you can in the future point that out and say, like, look, this person was behaving poorly. We had an order that was intended to prevent them from continuing to behave poorly, and they still behaved poorly anyway. And in the future, it is unlikely that a mere court order is going to actually change their behavior. And more likely than not, they are going to continue to behave poorly in the future, because this is just who they are. And that may support an argument to say, like, therefore, I should have more parenting time to, reduce the exposure to the children to these poor behaviors, or I should have final decision-making say for the parental responsibilities, because I can exercise good judgment and put the best interests of the child first, whereas this other person can't do that. This is similar. It just says, the other parties will not question the children about what the other parent does or what they do during their parenting time, discussing with the children any inappropriate adult, court, or legal matters, or blame, criticize, or disparage the other parent to the children. Again, same little footnote or caveat in terms of enforceability and how this might actually be practically useful to have. The thing with the inappropriate adult, court, or legal matters, if you have a child that's, 18 or 16 or something, like, chances are they're going to know what's going on, right? Children are a lot smarter than we give them credit for. A lot of them are a lot more mature than we give them credit for, and they're not stupid, right? They know. But the idea here is that you shouldn't be strategically telling them certain things like, oh, we're in this mess because of your mom, or, oh, look at what your dad did, and this and that, or, oh, you can't go to basketball camp or tournament or whatever because mom won't pay for it, or stuff like that. So just try to avoid things that can cause tension like that. But I mean, if they're just asking things like, hey, like, what's this court stuff going on? It's okay to, assuming that this is a 16-year-old we're talking about, right? Like, it's okay to say that, like, look, we're just having a bit of issues. We're trying to resolve it. And, it might take 6 months, a year, or however long it's supposed to take. And we'll keep you posted or something like that. When it comes to children who are quite young, so children who are, 5 or 7, it is ideal if you just don't tell them that there's court going on, or if they already know somehow, to try and minimize the impact. And in this sense, at least, the social study does support that approach, because children find it very stressful when they feel like they have to choose. And even if you're not telling them that they have to choose, if they sense that there's this conflict where it's a zero-sum game where one person wins and one person doesn't, they might still feel that internal pressure to, say like, oh, I want to support my parent, or I want to support both of my parents, and I want both of them to be happy, and I don't want this whole whatever else is going on. So just make good decisions with respect to your children and what you say. So this is the same thing, just, extending it to your family members as well. So even if you don't say anything bad about your spouse, if your mom or your dad, or your mom and your other mom is saying really terrible things about the other spouse, that doesn't help either. So just try to make sure that your children are not exposed to negative comments about either of their parents. Application format for conduct orders. So in Supreme Court, you can do it by way of a notice of application with an accompanying affidavit. In provincial court, you can put it in your original application about a family law matter. Assuming that this is already done, then instead of amending it, you can just file an application for case management order. There's a specific line or box, sorry, that you can check that says, respecting the conduct of a party or management of a case. So, in terms of choosing whether you apply for a conduct order or protection order, we've already touched on this one a little bit. So just a quick recap. If your primary concern is protection from violence, like future violence, especially if it's protection from immediate violence, then go for the protection order. If your concern is more just he's, like he or she are doing these, or they are doing these things that are not great, and it's harmful, but it's not like I'm concerned about my physical safety or anything else, and I'm not in any, mortal danger, etc. And then a conduct order may be more appropriate. So the avenue here is really going to depend on what it is that you're trying to accomplish. Okay, let's hit the question and answer for whatever it is that we just talked about since the last question and answer, and then we'll take a 10-minute break.
So one participant said they heard you say protection orders are meant to be standalone orders. Must they be applied for separately, or can you include protection orders in an application for other things such as support or parenting time?
So in that one, I can answer, thankfully, because it's about process, and it's the same answer for everyone. If you are in Supreme Court, you can include it in the notice of, if it's a notice of application that you're dealing with, you can put it in the notice of application. If it's a notice of family claim that you're dealing with, no, it doesn't really go there. If you are going to provincial court, then you have to file a separate form, because an application for a protection order must be made in Form 12. So no matter what other stuff you've got going on, it'll be a standalone application. In both cases, though, protection orders, the order itself, appear in a separate form. It doesn't go like, let's say like you appear in court and you get a bunch of orders, including a protection order. You're not going to get just one piece of paper with all of the terms of order. You're going to get one that deals with just the protection order and one that deals with everything else. And the reason why is because the protection order is going to be filed in the protection order registry. And you don't want everyone who can access the protection order registry to be able to see the rest of the stuff going on with your family law file. And also the protection order, ideally you should carry it around with you, because if you call the police to enforce it, in case, you know, the person is around you or whatever, you can give them a copy of that order and they are required to enforce that order.
Okay, so the next one, what happens if there's a communication order and it states something that no longer applies. So for example, if there is a communication order, the parties can only talk to each other through the lawyers and they don't have any lawyers anymore. Is that something that would have to be changed?
Yes, well, this is one of those things where, you know, court orders can say what they say, and of course you should always follow a court order because otherwise, you know, there can be some really bad consequences to you if you don't. Now, that being said, a court order can say that you and so must do these things, but if you both just agree between the two of you that you're not going to do that and you're going to do this other thing instead, no one's monitoring you. There is no independent body. This isn't like the book 1984. No one's going to come after you. So if the order says that you have to communicate through counsel and then you don't have lawyers anymore, and then you both agree, okay, no more lawyers, we can just talk through email and that's fine, then that's fine. Now, if one of you decides that this isn't fine anymore and then goes to court and say, hey, this order's been breached, yes, there's been a breach, but chances are a court's not going to do anything, especially if the other person can say, here's this text message where this person agreed that we can now talk by email. If you're really worried about it and you want to do it by the book, be all above board and all that, then you can go back to court and apply for a change. So again, Supreme Court notice of application, because that's what you use for pretty much everything. In provincial court, it would most likely be a request for scheduling, and you would say that you're looking to change an interim order. And then you would just explain that circumstances have changed and you can no longer follow the order as stated, and you would like it to be changed to this other thing instead.
Okay, so this next question here, I'll try to see if I can. So this one's about if you've ever seen any repercussions for a breach of orders in a family law case. If so, if so, was it, and in what circumstance, what is the usual outcome for a breach claim? So I'm not quite sure. I'm guessing
I
like
think
if
I can answer
somebody.
it. So
Pardon?
the consequences for someone breaching a court order is going to depend a lot on the nature of the order that was breached. So I can give some anecdotal examples here. There was one case quite recently that I was the lawyer for I was the lawyer for the claimant. And we've been trying to get financial disclosure from the respondent for about like 8 months or so. And we've gotten, you know, a couple of court orders to continue to try and get this disclosure in order to get the respondent to start paying like an updated amount of child support. Long story short, we didn't get the disclosure we wanted. We got some of it, but not all of it. And the other person was fined $5,000. And we were able to impute their income to whatever we said it was, because, you know, like if you're making less than what we say you're making, then prove it, right? So sometimes a court may say like, okay, well, you've had your opportunity to give all the documents, you didn't, so I'm just going to make the order that the other person is asking for. Sometimes it's about, you know, like parental responsibilities or parenting time or whatever it is. If you're breaching those kinds of orders, like for example, you know, you have to return the child by 7 p.m. on Friday, and then you just don't. You say like, and then there's no communication, no nothing. In the worst case that I've seen it happen, it was an emergency court meeting. It was an urgent court meeting. We had it in the evening. I think it was around 5 or 6 p.m. that we were in court. And it was ordered that the child be returned immediately or the police were going to get involved. And it was really bad. The parent that withheld the parenting time, they no longer had parental responsibility. So parental responsibilities was given to the other person. And courts will very frequently make that kind of order where they say like, look, you don't follow court orders. And because of that, we're going to give the other person the final decision-making say, because it makes it more likely that they're actually going to try and talk to you, whereas you are just going to do whatever you want. So yes, there are very real consequences. In the most extreme cases, it has resulted in a complete reversal of like what used to be called custody. We don't use that term anymore, but essentially, let's say, mom used to have all of the parenting time and dad sees the child one weekend a month or something. And then mom does a bunch of stuff where she ignores a bunch of court orders. The court might very well step in and say, okay, never mind. Mom can see the child once, one weekend every month, and then the child can stay with dad the rest of the time.
So this one is about, so it says, is parenting counseling recommended by courts for a parent or parents who are psychologically abusive?
It's going to depend on the case. Sometimes if you can make a case for it and say that this will assist in the parenting capacity of the parent that's supposed to take the counseling, a court can make that recommendation, or they can say like, okay, you can have this amount of parenting time until you complete this counseling program. And then after you complete this counseling program, you can have more parenting time. I've had some success with that where I asked the court for an order that says, dad can have parenting time in public places until he completes, this anger management program. And then once he completes it and shows that he's completed it, then he can have parenting time at his home. That's fine. So sometimes you can get stuff like that. Courts cannot force adults to do anything really. So they can't just say as a standalone thing, you will do this thing. But they can make certain things conditional, like additional parenting time or parental responsibilities, things like that.
Okay, so this one, I'm going to assume it's for when you're filing applications in provincial courts. When you file a form, will you need to include all your supporting evidence? So I'm going to think it's on the onset of when you're first.
Provincial court, it really depends on the form that you're looking at. Like a request for scheduling, there's not really a lot of room to write a bunch of evidence in there. Like an application for protection order, the affidavit is kind of built into it, so you want to put in more information there. Application for a family law matter, it's up to you. It depends. I mean, this is a personal preference thing or like a practice preference thing. Personally, I tend to not include too much information in the application itself, but then I will file a supporting affidavit with the information. And the reason why I do that is because, well, one, applications technically are not evidence, technically, except for the protection order because you have to swear it. But also, it's hard for you to go to court and then like refer to applications that you filed in the past, but it's easier to say like in one application you can refer to multiple affidavits. So sometimes, let's say like in an application for case management order or something like that, like under the facts section or something, I would just say, I am relying on the facts set out in my affidavit anticipated to be filed on the same day as this application, or I am relying on the facts as set out in the affidavit anticipated to be filed on the same day as this application, and also my 2 previous affidavits filed on this date and this date. So you could choose to do that, or you could just write it out. That's also fine.
When would it be advisable to get your child their own lawyer? And then they have a follow-up. So in what context would you have the child, I guess, set up an appointment with a children's lawyer?
So this is the thing. Technically, it's not a good situation if you're looking at a children's lawyer, because technically the test under the Family Law Act is that the parents are so incapable of communicating with each other, and the conflict is so bad that the parents are so sucked into this conflict that they're no longer able to act in the best interest of the child. And as a result of that, now we need like an independent advocate for the children's interests because the parents are no longer able to support that. So, by virtue of you even asking for a children's lawyer, you're essentially conceding and saying like, look, my spouse and I, it's so bad that we need an independent third person to protect our child's interests because we're not going to be able to do that successfully. It's not great, but theoretically, that's the bar. And that's why it's so hard to try and get one appointed. Sometimes the court will appoint one of their own motion. That happens a lot in Campbell River. Hence why I said Campbell River, there's a separate special case.
In execution, does emotional and psychological abuse hold any weight in the courtrooms? And then it says, the comment here is, I know it's written in the Family Law Act, but it seems that it's different when practiced in the courts.
You're not wrong. Whoever's asking this question, that is not wrong. Again, I've already said this before, and on behalf of the legal profession as a whole, I am sorry. We are not good at family violence. It's getting better, but it's very, very slow. And I say this because I recognize I've been in court where things have not gone well, and I've heard horror stories where things have not gone well. I've also been to court where things have gone well, and I've heard stories where things have gone well. So, you know, it really depends, and it shouldn't, but it does. And yes, like I said, there's still a bias towards physical violence being more serious for some reason or whatever it is, but keep trying. If you can point the court to case law, especially from the Supreme Court of Canada, like the Baron Drecht and Greblionis case, if you're going to, BC Supreme Court or BC Provincial Court, the judges are required to follow those decisions. It's not optional. The Supreme Court of Canada decisions are binding on those courts. They don't have a choice. They have to consider it and they have to follow it. So if you can, say like, look, my set of facts, my case is exactly like this other case, or, the court in Supreme Court of Canada in this case said that you have to consider these things, then at least in theory, they have to do that. Okay, so we're going to deal with communication pointers. So some practical tips on moving forward and staying safe. Set good boundaries. It's a lot easier said than done, especially if you're fresh and just brand new leaving an abusive relationship. It can be really, really difficult to set good boundaries. You might not know what good boundaries are. That's very common. Hopefully you can get connected to, victim services or a support worker or an advocate who can help you. I strongly recommend setting a new email address, either for your personal things, just in case you didn't have the best, electronic security before that, or even if you can set like one email address that you use to communicate with this other person. And then that way you don't have to be constantly checking it, etc., things like that. And by this, I mean, like, for example, like, let's say I just separated with my spouse. And so I make a new email address that's like, Valeska 12345 or something, or, Valeska parenting time only or something. And then I only use this email address to communicate with my former spouse. And then that way, they can only bother me when I choose to open my email and it's not so stressful. You can also use parenting applications. So there's Talking Parents app, My Family Wizard, AppClose. Talking Parents, I think it's around $15 a month, something like that. My Family Wizard's a bit more expensive. I do know that. AppClose is free. So, like shop around, see what might work for you. They can be quite helpful. Talking Parents is particularly helpful if you're expecting ongoing litigation, because they allow you to download a full transcript in PDF. And it says that it's a certified transcript that can't be modified electronically. So if you use it in court, like at least the court knows that there's an extra security there to know that it hasn't been tampered with. Safety plan. So, if you're worried about your physical safety, like you might want to think about, okay, like I don't want this person to know where I live. So I'm not going to put down my home address as my address for service. I'm going to use a neighbor's address or a friend's address, or I'm going to rent this PO box somewhere, etc. Things like that, right? Changing your phone numbers, etc., etc. Planning around upcoming triggers also really helpful. So often, the current social science and studies research that we have, psychology included, is that the first 2 years after separation is when there is highest risk of repeated or increasing or an escalation of violence. Typically, especially where there's coercive control, the perpetrator or the abusive person feels that they're losing control of the situation or the other person, and it's usually within those 2 years that they'll try and gain that control back. So 2 years after separation is an especially dangerous period. Now, once you've passed that, or let's say within those first 2 years, things are quite stable, there are other things that could be triggers. So for example, if you're about to serve them with a court application, or if there's an upcoming court appearance, that can be some triggers where you might want to make sure that there's some safety plan around those things. So, um, if it's a week on, week off parenting time, maybe don't serve them with an application right before their week, right? Serve it right at the end of their week so that they have a week to calm down before it's their parenting time again, or something like that. So some quick pointers, practically speaking, in communicating with your former spouse. So first one, very important, assume everything you write will be read by the court. And this is very important for several things. One, don't be rude. If you are angry, take as much time as you need to calm down, because if you are angry and you write down something that makes you sound angry, the court is going to think that you are like that all the time, and that is not good. And it's not even a fair representation of who you are anyway. Don't exaggerate, because if you exaggerate, say, let's say, the person was late, but they're late, like, 10, 15 minutes, 30 minutes, and it happens a lot and it's really annoying. And then you say, I've been waiting here for an hour and you are always like this, blah, blah, blah. Don't do that, because that's going to hurt your credibility later down the road, because they're going to say, like, here, you say that I'm late an hour every time. That's not true. And here's, other things that I can show you to prove that I'm not, because here are all these text messages where I'm telling you, hey, I'm here, I'm here, I'm here. And at no point am I more than 30 minutes late. That's going to make you look bad. Whereas if you didn't say that, it makes them look bad because they're 30 minutes late. And that's a long time for you to be waiting, right? So don't exaggerate. Your credibility is one of the most valuable things you can have going into court. So try to preserve that as much as possible. You need to have to get the court to trust you, especially because with family violence, so much of it happens behind closed doors. There's no corroborating evidence. So make sure that you do everything you can to be viewed by the court as a trustworthy person. Focus on problem solving, not on being correct. And I'm not saying this, don't be that person. It's not about that. It's about the fact that the other person is not going to agree with you no matter what. There is no point in wasting your time and your energy in trying to get them to agree with you, because they won't. So save your time, save your energy, go do something nice for yourself, or watch a movie, or whatever it is that you do to relax, instead of, spending 2 hours trying to get this other person to see reason. It's not going to happen. Just let it go. Try to find some compromise that you both can agree to. And if there is no compromise to be had, then just move on. You don't have to get them to agree with you. So same, that goes with number 3 as well. So 2 and 3 go together. Number 4, make your proposal. So make whatever it is that you're suggesting, whether it's the thing that you think is correct, or if it's the thing that you think is a fair compromise. Do try to be reasonable, but you don't have to compromise before they've even said something. And I say this because I see this a lot with my clients that are survivors of family violence. Is, I'll say, okay, well, so-and-so is asking for all of the holidays right now. So how about we do 1 year on, 1 year off? So this year you can have the child's birthday, and then next year they can have the child's birthday, and we'll just keep alternating, right? And then my client comes back and says, oh, they're not going to go for that. They're just going to lose their mind. They're going to get mad, and they're not going to go for it. It doesn't matter, right? Whether they go for it or not, it doesn't matter. If you write it down and you suggest it to them and you say, hey, we'll share it 50-50 year on, year off, it sounds reasonable. It looks reasonable. It looks fair. So if they then text you back and say, no, you are being ridiculous, blah, 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 then just take it to court and you can explain to the court, hey, like, look, judge, they wanted all the holiday time and all the birthdays. I proposed that we share 50-50 year on, year off, and then they refused. So now you look like the reasonable parent, and it looks like they're the ones being unreasonable. But if you don't even try to make that offer, now you both look unreasonable, because the court's going to say, well, why didn't you try to talk to this person before coming to court? Advocate for your agenda too. Same thing, like I noticed this a lot with my clients who are survivors of family violence. They're very used to just reacting to whatever the other person wants. And so typically it will be the perpetrators of family violence that's driving the agenda. They get to decide what issues are most important. So typically it's going to be a big fight about parenting time, or, holidays or extracurricular activities. And then we're not talking about child support, because they don't want to talk about child support because they don't want to pay any child support. So, advocate for your agenda too. The issues that matter to you are also important. There's no reason why we shouldn't deal with them too. So just try and keep that at the back of your mind, and periodically take a step back and think, okay, what issues are most important for me to try and resolve as soon as possible. The last one's kind of an obvious one. Don't threaten or harass your former spouse. Just don't do it. If you're going to say that you're going to take them to court, that's fine, but don't phrase it as a threat. You can just say, like, look, okay, we can either agree on this. This is my final offer, and if you're not okay with it, then we can deal with this in court. Or, we're going to have to try and get a court to intervene or help or something like that. That's fine, but just be mindful how you phrase it. Don't say, do as I say or I'll take you to court. That doesn't help. Stay away from inflammatory language. So don't try not to say things like my child, or, week 1 with primary parent, and then week 2 of summer with other parent. That doesn't help. It's true. Yes, they're your child. Yes, you may be the primary parent, but it's not great for a collaborative setting where you're trying to get them to agree with you or do what you want them to do, right? So in court, when you're telling the story and when you're arguing, sure, sometimes it makes sense to say things like my parent or I am the primary parent, things like that. Very often in court arguments, I will say things like, look, this person has been the primary caregiver for the entire child's life. And so I'll say things like, primary caregiver should have these responsibilities. Primary caregiver should make these decisions, blah, 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 blah. That's fine. But at that point, you're already in court. It's already too late. If you're not in court yet and you're just talking to them, try to avoid those kinds of language that might make them feel a little bit more defensive. Don't try to bring up concerns about safety if you can manage it. And I say this not to say that, those concerns exist. Okay. Yes, they exist and they're real and they're important. But I'm sure that we can all agree here that the perpetrator of the abuse is never going to acknowledge them or agree with you, right? If I'm an abusive, horrible person and I, like assault my child every time they do something that upset me or I'm angry with them, and then you tell me like, hey, kids are going to spend time with you for a week, try not to get mad and beat them up. What do you expect me to say? Right? I'm not going to say, oh, you're absolutely right. I'm so sorry for all the times I've done that. I will absolutely not do that. I'm not going to do that. More likely than not, I'm going to say something along the lines of, what are you talking about? I never do that. Blah, 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 blah. You're always throwing all these accusations at me and blah, blah. And then it's just a big fight, right? So you can acknowledge that these concerns exist. You can come up with plans that can help to protect your child and yourself and keep yourself and your children safe. But you don't necessarily need the other person to acknowledge it. I know that it's really important, and it's a vital piece of getting closure sometimes to get that acknowledgement. But realistically, unless you're in a court setting and you've backed them into a corner where they don't really have a choice but to admit that those things have happened, they're not going to. So again, it's a waste of time, it's a waste of energy, and then more likely than not, it's just going to cause a big fight. You can Google the BIFF response, BIFF. Available on Google, you can look it up. There's some people who are experts at this stuff. I am not one of them, but I've come across it. I have worked with a lot of clients who are survivors of family violence, and more than one of them have told me that they have found it very helpful. So the core principle is that when communicating with a person who has, narcissistic tendencies or who's a perpetrator of family violence, those two tend to go hand in hand together, surprise, surprise. Try to just keep whatever your communication is brief, informational, friendly, and firm. And friendly doesn't have to be super warm and sweet or anything like that. It's just a, good evening. I received your request. I think that we should do this thing instead. I think this is a fair compromise between the two of us. I look forward to hearing your response. And then you carry on. Or they're making allegations about this and that. You can say, I don't agree with what you're saying. I accept that you believe them to be true. By the way, this Sunday, are you still okay to drop off the child at this place? Yes or no? Thanks. Keep records of everything. and always assume that the other person is doing the same. So, you know, you never know when you might end up in court or you might need the corroboration. If there's anything where you can use it to either back up your credibility or where they're doing something they're not supposed to. So just try and keep records if you can. If you can, one way to do it is to either take screenshots, wait until it says the date, where you can see the date, so it doesn't just say, you know, yesterday or Saturday or something, but instead it says like, you know, June 21st or whatever. And then you can email them to yourself, and then that way it's all in one place, or put it on a USB or a Google Drive or a folder or whatever. And finally, probably most importantly, remember that this is a marathon, not a sprint, especially if you've got kids. You are in it for the long haul. So try to pace yourself. Don't burn yourself out trying to get everything perfect. Accept that you're not going to be able to get everything you hoped and dreamed of. And you'll just have to live with that and try to focus on the things that are the most important to you, the things that you and your child cannot live without. And that should be the priority. Communications with opposing counsel. It's not really all that different. A couple just quick notes. I recognize that sometimes opposing counsel can sound cold or distant or use legalese. Don't worry about it. Don't feel like you have to reply the same way. I have worked with self-reps on the other side, and they talk to me like they would talk to a friend, and they just say it how it is, right? And that's okay. That's fine. You just be yourself. We talk the way we do because that's how we're trained to talk, because we might phrase things to be as non-prejudicial to our client as possible. Don't pay too much attention to that. Some things to keep in mind, right? Everything you send to the opposing counsel will be passed on to your former spouse. There is that lawyer is working for your former spouse. That lawyer is also a facilitator. The decision is made ultimately by your former spouse. I have worked with clients before that have given me instructions that I don't necessarily agree with, where I don't necessarily think that, you know, this is perhaps the best course of action, but it's their life, it's their family. At the end of the day, they are the ones who are going to have to live with that decision, not me. And so I will follow their instructions. And so sometimes if you're, you know, you just feel like the opposing counsel is being really unreasonable, more or less it's going to be, you know, like it's coming from the other person. It's not coming from the lawyer. Sometimes the lawyer is the problem, but thankfully, at least on this realm, I can say the vast majority of the time, the lawyers are just following instructions. Remember that the opposing counsel are not there, they're not there to help you. Really, they're not. And you can ask them questions and sometimes they'll answer, but at the end of the day, their priority is the opposing party's interest, your former spouse's interest. They are there to advocate for your former spouse and your former spouse only. They're not required to be fair. They're not required to be reasonable. They're not required to you know, be a facilitator or anything like that. They are there to help your former spouse. So be very careful about what you say and what you expect. Make sure that you are advocating for yourself and your legal interests, and keep records of everything, because they're definitely doing that. If it's opposing counsel on the other end, they are definitely keeping records of everything, and they're not keeping records of everything that will help you. They're keeping records of everything that will help your former spouse. So if there's something in there that will help you, you keep that and you make sure that you have that somewhere accessible to you. So with communicating with opposing counsel, try to be polite. Remember that they're just doing their jobs. And I say this because, again, sometimes I do, you know, like I take positions that I don't necessarily think are the best positions to be taking, but I take them because those are the instructions of my client. So again, we're just doing our jobs. Remember always that they are advocates for your former spouse. That doesn't always mean that they personally identify with or agree with your former spouse. It's their job. Sometimes it can take a while to get a response. Don't be afraid to follow up. I don't, you know, go barraging and being angry and be like, you never talked to me and this and that and this and that, and how could you, how dare you, whatever. Just say like, hey, I emailed you 2 weeks ago. Can I please get a response? Just so you know, lawyers tend to be quite busy. And I'm not saying this because, you know, like our time is more important than yours. It's not that at all. It's just unfortunately, the reality of it is that because of the structure and how we run a family law practice, it's just that, you know, urgent things come up and sometimes we unfortunately take on more work and then we think it's going to be fine. And then suddenly a bunch of urgent things come up all at once and then it's not fine anymore. So for non-urgent matters, those tend to get put on the back burner, and it can take about 1 or 2 weeks sometimes to get a response. Keep in mind too that when you're talking to opposing counsel, they can't respond to you right away because they have to get in touch with the other person first. And there's been several times where I'm in a situation where, you know, the self-represented other party sent me an offer, and then I'm trying my best to get a hold of my client, right, to get instructions on how I can respond, and that can sometimes take a while. And I won't let you know that that's what's happening because that doesn't look good for my client, right? And I put my client's interest first. So I'm not about to throw my client under the bus. But this is just so you know that sometimes it can also take a while because the counsel might be having a hard time trying to get a hold of the other person. Opposing counsel will likely not want to talk to you over the phone. Don't take this personally. It's just standard practice that counsel will try to keep communications in writing where possible. We do this for several reasons. One, it's easier to use it as exhibits in court in case this ever goes to trial. Two, then we're not put in a position where we might have to be a witness, because if we are put in a position where we have to be a witness, then we can no longer represent our client. So we try to avoid that situation as much as we can. And also three, to not get in a position where you say, I said ABC, and then, you know, the other party or my client, I guess in this hypothetical example, is saying, well, that's not what my lawyer told me. My lawyer told me that you told them this, 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 this. So we just don't want to get into that. So if typically we prefer for it to be in writing so we can just forward it along to our clients. But also take advantage of the fact that you don't need to speak with your former spouse directly in case especially if your former spouse is the perpetrator of abuse and it's difficult for you to communicate with them directly. You don't have to. Now there's a person that's in between you and your former spouse. So hopefully that can at least you know, mitigate some of the stress or the triggers in communicating with a person that you know, obviously has treated you very poorly and has done some really horrible things. And in the very least, opposing, even if the other party, or in this case, you know, the lawyer's client or something, is swearing and calling you names or all of those horrible things, that's never going to make it to the written communication that gets sent back to you. So at least you can know that. If I can give you 2 pointers to take away that are important. One, you don't have to respond right away. I understand that, especially if it's your former spouse on the other end, it can feel urgent and it can feel that you have to respond right away. You don't, unless there's some external reason why it actually is urgent, like it's a medical decision that needs to be made and they're in the hospital or something. You don't have to reply right away. You can take your time. And also, you don't have to reply to everything. If they sent you, you know, 5 walls of texts with allegations of everything under the sun, of things that you didn't do, don't waste your energy trying to explain that those things aren't true. You can send just one line and say, that's not true, and just leave it there, and say, like, you know, I don't want to talk about it. Or you can just not respond. That's okay too. Not everything requires a response. Your time is important. You need to also prioritize your mental health and well-being so that you can, you know, care for yourself and your child. Okay, communicating with your children. So this is a little bit different than all the other stuff, because now we're talking about the kids. Don't communicate about legal proceedings if you can help it. If, you know, the children are like 16, 17, 18, that sometimes can't be avoided, but try not to put them in the middle. Do not use them as messengers. Just don't do that. Don't ask children to pick sides. Don't tell your children that it's the other person's fault, etc., etc. It may very well be the other person's fault, but you don't need to say that to the kids. And the kids may say, like, hey, you know, this is so-and-so's fault. Just, you don't have to agree. You don't have to disagree. You can just say, hey, you know, I don't think we should be talking about this, or try to divert their attention or conversation to something else. Don't negatively communicate about your former spouse or their family. Definitely don't interrogate your children about what happens in the other person's house. If they tell you freely, great. But if they don't sit them down and be like, okay, tell me exactly what happened from the time I dropped you off until you came back. And definitely, most certainly, under no circumstances, do not use or ask your children to collect or fabricate evidence against your former spouse. It's a terrible plan that is like really, really that's a really good way to try and get an alienation case made out against you. Don't do that. That's a terrible plan. Be very careful about phrasing conversations about safety, also because of the alienation piece. So if you say things like, hey, make sure that you have your phone on you at all times, and if you need anything, call me, okay? That's fine. But if you're saying like, okay, look, if at any time with your dad you feel like you're in danger or you feel threatened or you feel unsafe or your dad does anything weird, blah, 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 you tell me right away, okay? Or you call the police, blah, blah, blah. So if you're doing that and you're creating this atmosphere of danger, it's not great because that can again be used against you in the alienation piece. If that is really necessary, and sometimes it is really necessary, try to get a counselor or a support worker or maybe like a teacher or somebody at school or etc. who can help safety plan with the children, because now it's coming from a third-party professional and it's not going to be on you, right? Because sometimes those conversations are necessary, but you also want to protect yourself to the extent that you don't want to be seen as alienating the children, because that causes problems for you and ultimately your children, if the court decides that you're an alienating parent. It's in the long run not going to be good for your children. So with children as well, try to think about things long term, big picture. Keep conversations age appropriate, keep it light, keep it neutral. And also remember, last point, that courts can take a paternalistic approach to children. I recognize that children are mature and smart, and they deserve a lot more credit than we give them. I don't think that the current legal system is giving children enough credit or enough opportunity to be involved in decisions that are made about their lives ultimately. But you may agree with me or you may not agree with me, but what we can all agree on is that the courts don't see it that way. And we need to keep that in mind when we're thinking about how we want to communicate with the children and how we want to involve the children. And the answer to that is try not to as much as possible. There's a thing about alternative dispute resolution. Oh, that's it. You can say no. And that is really the answer to this. If there's concerns about family violence, with alternative dispute resolution, when you feel pressure to it, you can say no, it's okay. If you're in one of the provincial court registries that's required to go through that process, like for example, if you're in Victoria or if you're in Surrey, if you let the family justice counselor know at the needs assessment that there's family violence, they will release you from the mediation or from the alternative dispute resolution program. So you don't have to go through it if you don't want to. Some mitigation strategies, if you do want to, you can engage an alternative dispute resolution professional trained in family violence. Off the top of my head, Patrick Greyer from Greyer Law Office in Vancouver, he is excellent with family violence. So even where there is concerns about family violence, he can find ways to mediate those cases successfully, without obviously trampling all over the survivor of family violence. Have safety plans. It can be done in separate rooms, virtual sessions, in a courthouse in the presence of like a bailiff. You can have a support worker or an advocate accompany you. And for you personally, know your limits, right? Write your bottom line in advance and have it with you so that you're not pressured or bullied or coerced into compromising more than you otherwise would have. Be mindful of not giving in to those coercive pressures as much as possible. And assess your capacity to say no. If at some point in the middle you feel like, okay, I'm feeling really uncomfortable, I'm feeling really stressed out, I'm feeling really unsafe, and I feel like I'm about to get to the point where I'm just going to say yes to everything just to get away from all this, then just end the session. You can say like, look, I'm no longer in a position where I have enough autonomy or agency to actually engage in this process, and I need to leave. And that's okay. All right, so if there are any questions, I am here and we can talk about them.
So there was somebody who wanted you to re-clarify, I think it was a question that was asked earlier, if there was issues with a court order granted and they violated the orders, how would you rectify this?
If the issue is about enforcing an existing order, then the solution is you go to court. And you, in provincial court, at least you file an application for enforcement and you explain the situation and you say that you want this court order enforced. If in a hypothetical scenario, someone has already done that and it's not working out, and the real problem now is not about this order being breached and not enforced, but the real problem now is about the provincial court refusing to make the correct order, which is an order of enforcement, then you can think about appealing that decision and going to the Supreme Court to seek a review. That's kind of a bit tricky, especially if it's an interim order. I think with interim orders, you'd be looking at a different process. It's called like a judicial review or something like that. But there are ways to take a look at it. It's essential. But then at that point, it's not so much about enforcing an order specifically. It's more about saying that an order or a decision made by the provincial court was incorrect.
And for anybody whose questions are not answered tonight, or it wasn't exactly the answer you wanted, you can send questions to info@litigantschoolbc.com. So basically the emails where you get links to our weekly recordings and the weekly Zoom links. You can also send your questions there, and then we'll do our best to reach out to the presenter or try to answer the questions as best as we can. Okay, so this one, I'm just gonna read it verbatim and try to see if there's a way to comment on it. Is it common for the courts to order to force the child, especially in the tween-teen years, to do visits, contacts with the other parents, especially when there is a history of family violence?
That's answered in two parts. Is it common for courts to force children to attend parenting time? Let's say hypothetically, if the children don't want to. The answer is yes, unfortunately. Very sad, very depressing. I personally don't agree with it. But it is what it is. We work in the system that we have, not in the system that we want to have. There is an emerging body of case law where courts are very reluctant to force children to attend parenting time or make orders of parenting time against the child's wishes, where the child are seen as being older. That age is usually, you're looking at like 14, 15 and above. There's a couple of cases, I don't remember it off the top of my head, but I know that there's one case specifically where the judge said that it is not practical to make an order for parenting time for teenagers that is against their wishes. So, that now exists, and I have used it in the past to try and get judges to not make orders of parenting time against the child's wishes, where the child is, 12 or older. That being said, though, where family violence is concerned, it's one of those things, right? Like if you can convince the court to agree with you that yes, there is family violence, then theoretically they shouldn't make an order of parenting time that would put the child at risk of family violence. And if in the event that they do, then we're back in this situation where the court has made an incorrect decision, and then you'd be looking at an appeal to the Supreme Court if you're in provincial, or an appeal to the BC Court of Appeal if the original order was made in Supreme Court.
Okay. What is the current trend in the courts regarding accusations of parental alienation towards the protective parents? And I think this was touched on earlier.
It's not great. I mean, it still happens. There is a BC Court of Appeal case. I can't remember exactly the year. I think it was in like 2016 or something. It's called Williamson and Williamson. And the BC Court of Appeal in that case states that if you're bringing up parental alienation as an accusation or an issue or what have you, you have to be able to back it up with expert evidence speaking to the parental alienation piece specifically. And so this really answers most parental alienation issues, because in most cases people don't have that kind of expert evidence around. So at least there's that. But in terms of, in the case where the allegation was brought up, and let's say there is expert evidence to back it up, then it's really difficult. And it is still a common strategy that people will use to counter allegations of family violence.
Can you use things discussed or produced in mediation in court to use it as evidence? To use it as evidence is regarded as non-evidence without prejudice. So I guess anything that's talked or produced in mediation, can you use it in a court application?
Unfortunately, no, typically no. Everything that happens in the context of like mediation and other means of like formal alternative dispute resolution, things like that, they're covered by what's called settlement privilege. And it's this idea that because courts want to encourage you to be as honest and forthcoming and open and as compromising as possible in order to reach some kind of agreement, part of that encouraging process is that they'll tell you, look, whatever you say here stays here. So they're very reluctant to sort of, like waive or set aside that settlement privilege. So chances are no, you are SOL on that. I'm sorry.
All right. So this one's a bit of a long one, so I'll just do part one. Would you ever recommend not bringing up family violence in family court?
Yes, but not lightly. It is always an extremely difficult decision. And in any case, it's never my decision, right? So where I see this going sideways with a particular client, I've only ever done it once, thankfully, and I lost a lot of nights of sleep over it. But it was a conversation with the client just to let them know, like, look, okay, if we bring up the family violence, from what I know of the courts, here's what's likely going to happen. And if we don't bring it up, here's what's likely going to happen. And here are the safety concerns that you have. And here are some ways that we can address those safety concerns and still put protective measures in place without bringing up the family violence. Because there are other ways that you can try and get to the same solution or same outcome, but through a different means. And then ultimately, I left it to the client to decide, because in every case, it is up to the survivor how they want to handle that. Sometimes they might very well realize that it could go really poorly if they bring it up, but they need that for their own personal closure or whatever else it is that they need to move forward. And that's okay. That's their life and that's their choice.
Okay, and then the second part of this is, and I think you did touch on it, but I'll just ask it just in case. Do you think it'd be helpful, or sorry, do you think it would hurt the case more than help with the lack of weight in psychological and emotional abuse in court?
It really depends on the case. It really, really depends on the facts. Sometimes it's enough evidence of emotional and psychological abuse that, like it's clearly very relevant and we can bring it up. And then sometimes it's one of those things where it's a few little things spread out over time, where if you're living it, it's really bad. But if you're looking at it from a detached third-person perspective, it might not have that same impact. So it's difficult. Can't answer that one. I'm sorry, not because I don't want to, but because there is no right answer.
No, fair enough. Okay, this question here, if opposing party adjourns an issue generally, how long do they have to go back to court? So I guess like
Potentially forever. Adjourn generally is another way that lawyers say we are never dealing with this ever again. Yeah, if you want to bring it back to court though, and assuming you're in provincial court, you can do that by bringing a request for scheduling. There's a little checkbox there for one of the options that says that this matter was adjourned and wasn't set to a specific date. And then you can say, I now want it back in court.
okay. So this one here, is it true that prenups, or I guess marriage agreements, cohabitation agreements, are not, sorry, for some reason, keeps blocking my screen. Is it true that prenups are not well looked upon by family court?
No, that's not true at all. I don't think so. No, prenups are very enforceable. They are upheld in court very, very, very regularly. It is in fact extremely difficult to try and set one aside. The one thing that prenups cannot do is that it cannot deal with children, not child support, not parenting arrangements, not nothing to do with children. And the reason why is because anything that has to do with children has to be determined only considering the best interest of the child. And obviously you can't know what that is before you've even separated. So prenups, no good for parenting stuff. You can deal with parenting stuff at the separation agreement.
Okay, and I think that's it for the questions. So again, if anybody does have questions, even after we end the session today, again, you can send your email or email your questions to info@litigantschoolbc.com. And we'll do our best to answer the questions, or I'll try my best to reach out to the presenter to see if they can help answer some questions. Thank you so much for tonight. Oh, this was so helpful, so informative. Had some great feedback from some of the participants. They thank you so much for everything you've presented tonight. The communication pointers, very, very helpful. Good reminder. I know even for me, it's a very good reminder to, to have, I might even have a list of that just staying somewhere because I think it's really helpful for everybody to know. It's a good way to kind of take a step back, take a second, especially when it comes to dealing with opposing counsel. And I know when I help self reps, I understand how they feel, right?
Oh,
Um,
it can be really frustrating. Trust me, I know. Lawyers get frustrated at other lawyers too. We're all human.
yeah,
And if I can say like one parting thing at the end of all this, like everything I've said, like it's one of those things where it's a lot easier said than done, right? And if I'm being like perfectly honest with all of you here today, I, like I probably can't follow all of that if it was my own family law case. Emotions are high. I'm human too. I'm going to make a lot of mistakes and say and do a lot of things that I probably shouldn't. So in the event that you're one of those people that have done those things, just you're human. It's okay. Just keep in mind the big picture and trying to move forward.
right. Okay. Well, thank you so much for presenting tonight. Thank you, everybody, for all your questions and coming and attending tonight. So we'll see you next week for week 5. We'll send a reminder with the link for next week, and we'll send this recording out towards the end of the week. All right. Well, have a good night, everybody.
Have a good night, everyone. Thank you so much for coming. And Jennifer, thank you so much for your time, for having me, and for fielding all the questions. That was really helpful. Thank you so
No,
much.
thank you. Thank you so much. All right, I'm going to stop this recording.